In this video, we're going to examine how John Marshall demonstrated by example the meaning of our oath by defending the Article 5 Convention of the People. The beginning of the McCulloch versus Maryland case starts by Chief Justice John Marshall addressing Maryland's claim that sovereignty under the U.S. Constitution does not emanate from the people, but from the states. Chief Justice John Marshall aims to shut Maryland's position down and states very clearly that the convention was elected by the state legislatures, but the Constitution was a mere proposal without obligation. It was reported to Congress with a request that it be submitted to a convention of delegates chosen in each state by the people. Moreover, the U.S. Constitution and the laws made in pursuance of it are supreme, and they control the Constitution and laws of the respective states. And this leads to some basic corollaries. The power to tax involves the power to destroy, and the power to destroy would defeat and render useless the people's power to create their own government. Likewise, obviously, the power to amend would also involve the power to destroy, and it must be kept to the people and away from the state legislatures. And if the states had the power to tax the American government, then in fact the U.S. government would not be supreme. And the same would be true if the state governments had the power to amend the U.S. Constitution, that the U.S. Constitution would not be supreme over the state governments. This was not intended by the American people. They did not design to make their government dependent on the states. This may be the most interesting part of the story. After McCulloch versus Maryland came out, it was challenged in the newspapers, and Chief Justice John Marshall felt so strongly that he had to respond to the false claim that the Article 5 Convention is a convention of the states, that he wrote his own article under the pen name A Friend to the Union. A lot of people don't know about A Friend to the Union because when he first wrote it, the newspaper that published it had mixed up the pages. And so it didn't look like it was written by someone of his pedigree, and it was overlooked. It was republished a month later, but history had already passed it by until in 1969, Gerald Gunther of Stanford University Law School published John Marshall's defense of McCulloch versus Maryland. In the article, Chief Justice Marshall makes clear that the powers of the U.S. government were delegated by the people assembled in convention, not by the state legislatures. And Marshall brings the evidence. He refers specifically to the preamble. And he states clearly that the preamble cannot be construed to mean we the states, etc. Marshall makes clear the Constitution was not intended to be submitted to the decision of the state legislatures, nor was it. It was referred to conventions of the people for their assent or ratification. And quite clearly, those conventions of the people were of delegates elected directly by the people for the special purpose of amendment. Even if every state legislature had been hostile to the Constitution, it still would have gone into operation if assented to and ratified by the conventions of the people. Here, Marshall stresses what was already stated in the McCulloch versus Maryland opinion, that the Constitution, when it came from the hands of the convention, was a mere proposal without any obligation. Its whole obligation is derived from the assent and ratification of the people assembled in state conventions. In Marshall's A Friend to the Union article, he makes more clear than he did in the McCulloch versus Maryland case that when parties are using the word states, they're using it in a distinct sense from the term people when talking about constitutional convention and amendment. And Marshall makes clear the point that the Constitution was submitted to conventions of the people, where those delegates were elected directly by the people for the special purpose. And it was from these conventions that the Constitution derives its entire authority. Finally, and most importantly, Marshall makes clear that the Constitution is not to be amended by the legislatures of the states. Marshall says that the states can only decide on those amendments which have previously been recommended to them by Congress, or they may require Congress to call a convention of the people to propose amendments. And here is your evidence of intent of the framers and ratifiers of the U.S. Constitution. It wasn't just the state ratification conventions that were conventions of the people. The Article 5 convention itself is a convention of the people, and that is what John Marshall is saying here. It's also some early evidence that there's a gap in the Article 5 convention clause, and that's why John Marshall is stepping up to his oath and making sure it is clear to the American people that the Article 5 convention is a constitutional convention of the people, where the people get to elect their own delegates for this special purpose. John Marshall demonstrated to us the meaning of our oath. When there's a challenge as to who is sovereign in the United States system, we must step forward on behalf of the people as sovereign, not the state legislatures. He defended the convention of the people for proposing amendments, and this is the meaning of our oath.